This is the John Oakley Show podcast.
Let's get busy. Hour two. It is a great day for talk radio, the Friday edition. Of course, Danny was just mentioning, very cold, bitterly cold, continues through the weekend. And then, of course, next week I'll be away. So
there will be no weather.
It doesn't make any difference to me. So it's like the tree falling in the forest. If I'm not here to experience it, how do I know how cold it is? Right? Little philosophy there for you. Okay, Socrates, let's move forward. On these matters of McArthur and Bissonnette and the sentencing, I've been on record as suggesting that these things seem disproportionate to the heinous nature of the crime, but we've heard from the legal community that there may be reasons, including the judge, for sentencing no parole eligibility for McArthur for 25 years. Not that he's ever going to see the outside walls of a prison because he's going away for the rest of his naturals, but the symbolism of 25 years, I mean, as opposed to 50 or 200 for that matter, I'm a big fan of symbolism. Let's see why the judge decided, in many people's opinion, he went light on this. Joseph Neuberger has joined us, Global News Radio's law expert with Neuberger and Partners. Joseph, good afternoon.
Good afternoon, John. How are you?
I'm very good. A little bewildered. I mean, where the judge in the McArthur sentencing gave 8 concurrent life sentences, and he won't be eligible for parole for 25 years. So it's not consecutive, as the Crown had been looking at, or a lot of people had been braying for. Do you have a problem with that?
Not really. I've been able to review the judgment briefly, and I have to say tremendous respect for the judge who was handling this sentencing. He's an exceptionally seasoned judge and a former prosecutor who handled very complex and difficult murder cases. So first, he's not a light touch. 2, he's very pragmatic. And in this instance, the heinous nature of the crime speak for themselves. But what His Honor put some emphasis on, which I agree with him, is 2 things. One, it seems that Mr. McArthur's approach from the get-go was working towards a resolution. He waived the preliminary inquiry, and then even when they went to Superior Court, the idea was to work out a resolution. So that has a tremendous mitigating factor that has to be considered by a court, because you can imagine other individuals like Dellen Millard who would savor in the spectacle of a trial that puts the families and the community through not only horrific trauma of reliving it in a trial, but great expense to our tax dollars. Mr. McArthur didn't do that. And as much as he did not express remorse, his plea of guilty to 8 counts without any mitigation with respect to the facts, I think is fairly significant. And His Honor placed emphasis on that. And second, the parole eligibility of 25 years will put him at age of 91. And His Honor correctly noted that his chances of parole at that stage are slim to none, because the parole board will look at the exact factors that a court will look at, will be the nature of the offense, the violence, the serial nature of it, and the effect to the families, etc. This gentleman is never, ever, ever going to see daylight, and so it is symbolism, as you exactly said. And in Canada, we've never been really given to the United States style of sentencing, where you get 200 years and 300 years. And as much as it may feel good from a symbolic standpoint, this is closure. There is some credit given to the fact that he's pled guilty. There is an end of the proceedings. And the reality is the community can rest safe. Is never going to get parole. Again,
with Joseph Neuberger, he's Global News Radio's law expert on the sentencing today of Bruce McArthur, as well as Alexandre Bissonnette in Quebec City. On this McArthur sentence, where the Judge McMahon said sentencing the accused to parole ineligibility until he's 116 years of age is symbolic, which is what the Crown and I'm arguing for, frankly. But then he goes on to say there's a fine line between retribution, which is an appropriate sentencing principle, and vengeance, which I guess he's intimating is not. So what's the distinction between retribution and vengeance?
Well, vengeance is where you're going to inflict as much punishment on somebody simply to hurt them. Retribution and denunciation are 2 very important principles to deal with the specific conduct and rebuke it. He doesn't want to see, I think by what he's articulating, is that our sentencing regime goes to the end of being a vengeance type of sentencing. And it's again because we've had a very balanced system in Canada for decades and for a very long time. And I think we're all served very well by having such a civil balance system in Canada. And so he wanted to draw that fine line because the reality is, rather than trying to placate those who may want a vengeance type of sentence, what we are looking at is protection of the community, denunciation of the horrific nature of these offenses, and the fact that this individual really will not get parole. 91 is just really a benchmark where he may have a parole hearing, but it's just not going to happen.
All right, so vengeance is
realistic.
Vengeance is off the table. I guess the argument is similar to why we decided to scotch capital punishment, because supposedly it coarsens the society. That's one of the, if you lapse into barbarity, this is the argument that was made, therefore we ought not to. Notwithstanding that there may be some cases where people were unjustly accused and went to an untimely end. So you're saying vengeance does, again, have a corrosive effect?
It does. I think it does. It's particularly in Canada, the way we deal with things in the criminal justice system, I think it can be incredibly corrosive and not helpful.
Again, with Joseph Neuberger, let me just pivot over here to the Bissonnette case, where likewise the judge decided that a life sentence with eligibility for parole between 35 and 42 years is fair and just. He killed 6 people. I mean, again, a lot of people are curious why that seems to be the yardstick.
Well, that again, the sentences were to be the murder sentences were concurrent, and then he added 15 years on top for parole and eligibility for the 6th count. And so we calculated 40 would be appropriate in these circumstances. He took a similar approach to say that a 150-year sentence would be cruel and unusual punishment. And when we look at it again, it's a situation where I think the judge is trying to strike a balance between what are appropriate sentencing principles in Canada and really what is reality, as opposed to going to the side of vengeance and creating a symbolic sentence that really is meaningless. Again, this individual, Bissonnette, who's involved in such a callous, horrific type of act, killing these defenseless individuals and wounding and maiming others. Again, chance of parole at 40 years for this individual is also slim. Their risk profile can be off the charts given what they've done. And so this is an individual, again, who, may be highly unlikely ever to see daylight again.
Well, we would hope that, but I mean, the window is such that he would be at least eligible by the time he's 67, and that should maybe give us pause, but you're saying the chances are very, very slim and none. Let me ask you another thing, because I'm kind of curious. In cases like, with Bissonnette, if you're trying to defend the individual in this heinous act and whether, you're trying to prove he's not criminally responsible or he's got mental health issues, when it comes to expert witnesses in a courtroom, who decides who the expert witnesses are and who lends credence to what they have to say?
Well, in a case like Bissonnette, there's no defense of mental disorder that was applicable. But in other cases where there is an NCR defense, there's various ways that you go about it. So the defense would retain experts who are commonly known and well respected in the area of forensic psychiatry, and they will do assessments. And then also there can be a court-ordered assessment where the individual will go off to either the Center for Addiction Mental Health or some other facility for a court-ordered assessment. And then in some instances, in the case I have, we consented to the Crown picking their own psychiatrist and doing an assessment as well. And then if it comes to a trial, all experts will have their reports filed and then will testify, and it's up to the judge to determine what evidence he or she wants to accept and put great weight on in determining whether the defense has been made out under Section 16 of the Criminal Code.
All right. So it rests with the judge ultimately, and because people might be shopping for sympathetic testimony, right?
Yeah, and so NCR cases can be run in front of a jury as well, but a lot of the time it's judge alone. But if you want credibility for your own position as a defense lawyer, you're going to be choosing experts who are generally well-respected and well-regarded. And again, in Canada, the experts who are quite well-known in this forensic field often are retained by the Crown, often do individual court-ordered assessments for dangerous offenders and not criminally responsible and fitness. So these are individuals we see very commonly in the criminal justice system, and so they have inherent credibility. But sometimes experts will differ with respect to what a diagnosis may be and how it played out in certain circumstances. All
right. Well, Joe, it's always comprehensive when we talk to you. I really do learn a lot. I appreciate your time, and have a great weekend.
Thanks, John. Take care. Be well.
You got it. Joseph Neuberger, Global News Radio's law expert with Neuberger and Partners.
Thanks for listening to the John Oakley Show podcast. Be sure to rate, review, and subscribe for free at Apple Podcasts, Google Podcasts, and anywhere else you get your on-demand audio.